Okay, hello again, everybody. YouTube live presentation number 19. Can you see me okay? Can you hear me okay? So just having a little fun now that I'm getting kind of comfortable with the software, the YouTube live software. A couple of minutes before we jump into the presentation. Big one today, it's about the Medicaid stuff, which really everybody needs to know about, even if it won't apply to them. It may apply to a parent, a grandparent, a relative, an aunt or uncle, friend. So it's really good information for people to have. Having the information before you need it is imperative. So we'll go through all the reasons why and all of that. So general housekeeping, I love the live chat. Kurt, I'll definitely be keeping a close eye on my man Joe Burrow. I'm expecting big things. Kurt sent me a message yesterday. He knows I'm in Baton Rouge. He knows Joe Burrow, who was selected first by the Cincinnati Bengals, was our quarterback. We had a pretty good year last year. Old Joe Burrow won the Heisman Trophy in the largest margin of victory in Heisman Trophy history. Our team went undefeated, 15-0, and along the way we beat 7 top 10 teams from Clemson, Oklahoma, Georgia, Alabama, Florida, Georgia, Texas. And, many experts in the college football field say we had the greatest season in the history of college football. So, we had a pretty good year. So our quarterback, Joe Burrow, was responsible for a large part of that. I'll be watching him as he quarterbacks the Cincinnati Bengals, hopefully to a few victories this year. Good morning, Alex. All right, so feel free, just jump in with some live chat, maybe where you're from. I'd love to know what state you're listening or watching from. I've been curious about that. I've been meaning to ask you for a while, so throw in your state where you're from and it'll give me an idea. Always as we get started, we have so many good questions either in the live chat or as comments from other videos. So I like to go through maybe the questions that were asked in the last few hours and just address some of those. Here's one from Barbara Anderson, 22 hours ago, wrote in a comment to a question: bank is requiring EIN, which stands for Employer Identification Number, for trust since both parents have died. On the SS4 form, is the type of entity now estate? So very good question, Barbara. Actually, on the SS4 form, which is the IRS's form to apply to get a tax ID number, estate is not the right box to check. It's trust. So it would be estate if your parents left everything in their names and you were going through a probate and assets were in their probate estate. Yeah, it would be estate, but actually their assets are still in their trust. And so trust is the right box to check. And just as a side note there, as people establish revocable living trusts, the whole SS4 needing a tax ID number thing is a non-issue, because people who set up revocable living trust, they can use their own social security number as the tax ID number for the trust. The trust doesn't file any tax return. The trust doesn't pay any taxes. All of the income just flows through to the settlor's income tax return. But when the settlors die and that trust becomes irrevocable, then it's no longer one of these grantor trusts that permits you to use your social security number. The trust applies for and gets a tax ID number. So, okay, so there we go. All right. Ohio State. The old Buckeyes. Yeah, just a team we beat in the national championship the last time we won the national championship. And I was there at both of those, both one this year and the one, it was 2008. Is that right? Yeah, 2008. And so, but, y'all got a good team and a good coach and all that good stuff. Okay, so that's that. Let me see if I have any others. A related question from a different person. William Beasley, 20 hours ago, wrote, question on RLT after last settlor dies. What tax forms are required for both the now irrevocable trust and the dead settlor? Well, the dead settlor, it's likely that their final income tax return will have to be prepared. If they died, here we are, June 24th. If they died on June 24th, 2020, then in in the first part of 2021, their final income tax return is likely to have to be prepared, filed, reported for all of that income from January 1st through June 24th. And then, maybe an SS4 to get a tax ID number for the trust. And then depending upon how much income the trust has from the time the settlor dies until the assets are dispersed to the beneficiaries, then that trust may need to file an income tax return to report income that it has in that interim between when the last settlor dies and the distributions are made to the beneficiaries. So that's an idea there. All right. So that's about it for the questions for now, I think. There's always the negative Nellies. I just know anything you do. So and sandwiched in between Donna and Randy saying such great information, thank you. Sandwiched in between LW saying, asking what about Florida law. Sandwiched in between Trish, who says thank you for your time and sharing your knowledge. Sandwiched in between Sheikah, who said excellent explanation, thanks for saving time, excellent. There was the comment from MDVD Bo, who said blah blah blah, remember KISS means keep it simple stupid. So anyway, just throwing it all out there for fun. Got 2 Louisiana people in the house. That's fantastic. Great state here, as are really every state. There's great people. So, but good to see some Louisiana people in the house. Here we go. Let's jump in. The old protecting it from the nursing home conversation and what's the deal for 2020. Big issue out there. Some people don't discover the issue until it's too late to do anything about it. More about that in a minute. Some people discover the issue early on, but they handle it the wrong way. More on that in a minute. And before I get into all the strategies and how to protect and, do you keep it in your name? Do you create a trust? All the legal mumbo jumbo that I'm going to have to go through in a little bit. Let me just hit the kind of elephant in the room first, which is the whole concept of living in a nursing home, particularly since the coronavirus started and nursing homes were in the news on a daily basis because many residents were getting sick, many residents were dying. Even before that, people in general, didn't like the concept of having to live in a nursing home. And quite frankly, I don't blame them. I've been in a lot of nursing homes. My grandmother was in a nursing home for 20 years. My wife's grandmother was in a nursing home for somewhere around 10 years. Johnny, good to have you back, or good to have you here. Awesome. So the nursing home thing, we got to talk about it. And a lot of people have given me their thoughts about the prospect of having to reside in a nursing home, all the way from kind of the gentle conversation of, I really don't have a problem if I have to go into a nursing home in the future. I know it's just a fact of life. I don't want to be a burden on my children. I don't want my children having to take care of me. So I've come to the realization that one day I may have to reside in a nursing home. That's on this end of the spectrum. And then I've had the conversations that go all the way to the other end of the spectrum, which are, they ain't no way I'm ever going to go to a nursing home. And usually it is kind of couched in terms of, my daughter has insisted that she will never let me go into a nursing home. And quite frankly, when I hear that, the daughter's probably right. I mean, if she feels that strongly about it, then there's probably already plans being made for the extra room in the daughter's house. There's already, taking a look at the financial resources of daughter and mom or parents to make sure that can make all of that work financially. So I kind of believe the children of the parents when the children says, they ain't no way I'm putting my mom or dad in a nursing home. Those feelings are so very strong. So it's one spectrum or the other, but we got to talk about it. Yes, there have been a lot of really bad situations with nursing homes and the coronavirus. Lots of illnesses, and as you all know, the coronavirus impacted those with elderly with the health conditions more so than the younger crowd. I got to tell you, I'm quarantined in my house right now. My 19-year-old daughter tested positive, so my wife and I and my daughter are here. She had some flu-like symptoms for about 3 days around the time that she got tested positive. Much better now, all cleared up, but we're still quarantined. So I get the whole coronavirus thing. Okay, so, but we got to talk about it. And most people, I think, realize, I think most people, that middle group, there's the extreme of piece of cake, I'll go there. And there's the extreme of it ain't happening, never. And, you see a lot of males in particular saying, I'm not sure if they're half joking or they're half serious or they're 100% serious. I'm not going to a nursing home. I'm going to take care of it before I go to a nursing home. They tell me that. I'm like, wait a second here. So anyway, people have strong sentiments about nursing home, and I'm talking about the long-term skilled care nursing home. I'm not even talking about at this point the the assisted living facilities. Those are two different arrangements. Assisted living is all private pay. Nobody on Medicaid and assisted living. They have their apartment. They're paying for it. And so, Ron, good to have you back. I think we missed you yesterday. And, since you set the standard, you got to throw a joke up in there. But we'll give you a pass this time for being late. Tomorrow's the finale. So I'm going to expect you right on time. Good to have you, Ron. Okay. So once we get past, and I'm going to assume for purposes of this webinar, we've now gotten past the conversation of a nursing home just may be necessary for some people. So we got past that. So now it's, given the fact that may be necessary in our future, because most people say, I don't want to go to a nursing home. I don't plan to be in a nursing home, but you never know what might happen. I might have a stroke. I might get dementia or Alzheimer's. I might fall and break my hip, and I'm not going to be able to live independently. And it might get to a circumstance where my spouse can't even keep me in our home because I require more care than my spouse can provide. And, having someone in the home would be ideal to help take care of me or us, but having that 24/7 care in the home, that's an expense that is outrageous, often in excess of $10,000 monthly for that in-home care around the clock. Medicare doesn't pay for Medicare, which is, health insurance for senior citizens. It doesn't pay for, long-term skilled care. And so, some people say, I don't want to go to a nursing home, but it may be a necessity. So if it's a possibility, and since it's a possibility, what can we do to protect what we have? We want it protected. We want it for ourselves. We'd like to pass along what we have to our children, and we worked hard for it. How do we do it? So that's what we're going to talk about for the rest of the YouTube live presentation today. And I'm going to start the presentation, and if we are build an addition to our home, turning a den into an AD for the mother-in-law, she insists on paying the construction costs. Should we place her funds in the irrevocable trust prior, or does it matter? My quick answer is yes. She gives you the money to pay for the addition, and you spend that money, and it was a gift to you. And as long as she doesn't go into a nursing home for 5 years beyond that gift to you, then you're good and no problems there. And it sounds like that would be the case, because your plan, if you're doing construction to enable your mother-in-law to reside in your home, she's probably not going to go in a nursing home for the next 5 years. So, and we'll get into that a little bit when we talk about some of the transfers and penalties for transfers, but that's a good question. So whether she gives you the money and just as a donation, and you use the money for whatever purpose, including making improvements to your home, or she puts that money in an irrevocable trust. It's the same potential Medicaid eligibility. In fact, both of those are considered uncompensated transfers that result in this 5-year penalty look-back period or penalty period that we'll get to in a minute. All right, good question, Johnny. All right, so I'm going to start it off by giving you just two examples that show you kind of the consequences of either doing nothing or taking some action. So my first example, I'm going to call them Pat and Martha. They're 70 years old, and they're of the mindset that, kind of doing nothing is okay. They've worked hard. They have a house maybe worth $300,000. They've got some financial accounts, various accounts, maybe totaling $400,000 in vehicle. They've got a couple of cars. They're your typical middle-class American family. They just leave everything in their name. Yes, they probably got wills and powers of attorney done. So, to make it to leave things to each other and then to their kids when both of them pass away. But the concept of doing more than that in case they go to a nursing home, they've never heard of that, or they've heard of it, but they just maybe didn't feel like it was necessary for them. So they're 70, fast forward 78 years later, Pat at age 78, he has a stroke. Martha can't take care of him. He goes into the nursing home. They're a married couple with one spouse in the nursing home, one spouse still at home. And so Medicaid discovers, or they discover, quite frankly, that they have more than this community spouse resource allowance of $128,640 of countable resources, because their $400,000 of financial accounts and their second vehicle is a countable resource. So they've got to spend those assets down until the total of their countable resources is less than $128,640. Again, that's the resource limit when one spouse is at home and one spouse is in a nursing home. Your state may be slightly different. I'm giving you the Louisiana numbers. Quite frankly, federal Congress makes the Medicaid law, but they give states states administer their own Medicaid program. So it's kind of a combined federal and state program. States have some leeway as to what some of the regulations are for their particular state, but they must comply with the federal rules. So in many states like ours, the number gets increased each year gradually for inflation. That's why it's an odd number, 128,640 for 2020. So Pat goes into the nursing home. They tell Pat and Martha the nursing home costs $9,000 a month, or whatever the number might be. Pat and Martha, you'll have to spend and your own resources down from until you have less than $128,640 of countable resources. And then Pat can qualify for Medicaid, so that Medicaid pays the nursing home cost. Okay. So they do that. They spend their $400,000 of financial assets. They sell the second car. They spend all that. And they spend, roughly about $270,000 over the course of, several months of Pat being in the nursing home. And they do spend it down to $128,640. And then Medicaid starts paying for Pat's nursing home care. Well, a couple of months later, Pat dies. And so now Martha is at home, and let's say she gradually gets dementia, and then she goes into the nursing home with her $128,640 that she could have when Pat was alive and on Medicaid. But now she's a single person and a different rule applies. So Martha will have to spend that $128,640 on her care, $9,000, $9,500 a month, whatever it is, until she has less than $2,000 in her name, because that's the rule, countable resource rule for a single person. So it'll take her about a year to spend that $128,000 down to less than $2,000. And at that point, then there's no more money. There's no second vehicle. All that exists is a home, which was an exempt asset. But once Martha spends everything else down to less than $2,000, then Medicaid starts paying for Martha's nursing home care as part of Martha's Medicaid application, which may be her daughter does for her because her daughter has power of attorney and Martha doesn't have the cognitive ability to be able to fill out a Medicaid application. As part of the application process, when Martha applies for Medicaid, when she has spent everything down to less than $2,000, the Medicaid office on all of the application forms notifies Martha and Martha's daughter, hey guys, Medicaid is going to pay for Martha's nursing home care. However, Martha still has a home in her name. And yes, it's an exempt asset. It doesn't count toward the $2,000 of assets that Martha can have. However, our state's estate recovery laws require us to pursue the amount that we spend on Martha while she's on Medicaid. So we're just letting you know, when Martha dies, we're going to expect you to sell the house from her estate and give all of that money to us as reimbursement for what we spend on Martha now that she spent all of her own money. So Martha goes on Medicaid. Maybe she lives another 3 years. Maybe she spent another $350,000 of Medicaid dollars. She dies. Medicaid pursues its estate recovery rights. The kids or the child, whoever the executor is, sells the house in Martha's estate. And because Medicaid has these estate recovery rights, the money goes into Martha's estate and then it's paid back out to the Medicaid office in the state to reimburse them for what they spent on Martha's nursing home care. And Martha and Pat's 2 children wind up with zero and a big headache. So that was the if Pat and Martha do nothing conversation. Let me tell you also about their next door neighbor. And their next door neighbors, good friends of Pat and Martha. They were neighbors for many, many years. And Pat and Martha's neighbors, their names are Brian and Lisa. And when they were 70 years old, they kind of realized that there was the potential for that, one or both of them just might have to go into a nursing home in the future. So they looked into it, they took some action. Here's what happened. They wound up creating, I'll call it a family trust. They wound up transferring their home, their financial assets to their family trust. They did that when they were 70. And so more on that in a minute, the particulars of the trust, but let's just stay with me here. Exact same circumstances happened to Brian and Lisa as did Pat and Martha. 8 years later, when Brian was 78, he broke his hip, did whatever, he went into the nursing home. As part of the Medicaid application process, when Brian went into the nursing home 78, have you transferred any assets out of your name in the last 5 years? No, 8 years ago, I transferred assets out of my name into a trust, but that wasn't in the last 5 years. So to answer your question, have I transferred anything out of my name in the last 5 years? No, haven't transferred anything. And then the assets in their name, the countable resources in Brian and Lisa's name were less than the $128,640 community spouse resource allowance. So since that was the case, Brian was eligible for Medicaid. Medicaid started paying for Brian's nursing home care. Brian dies a few months, few years later, whatever the case may be. Lisa gets dementia. Lisa gets Alzheimer's. She goes into a nursing home. Ask Lisa the same question. Have you made any transfers in the last 5 years? No, haven't. Lisa has less than $2,000 in her name. So when Lisa goes into the nursing home, she qualifies for Medicaid. All the while, this $300,000 home is in this family trust. These $400,000 of funds are in the family trust. Maybe one or both of the vehicles is in the family trust, but those aren't big ticket items, so I'm not going to really worry about those. And then when Lisa goes in the nursing home, she applies for Medicaid, she qualifies, as we'll get to that in a minute. And so a few months or years later, Lisa passes away, and there's not even a probate necessary. Yes, when Lisa applies for Medicaid, they tell Lisa and Lisa's children, Medicaid has these estate recovery rights. So to the extent you have assets in your estate when you die, Medicaid can pursue them in estate recovery. But when Lisa dies, there's nothing in her estate for Medicaid to pursue. So the distributions are made from the family trust, half to child number one, half to child number two. All of the family assets are preserved. Roughly $700,000 to $800,000 of assets are preserved for Brian and Lisa's two children. So that is the kind of if you don't do anything versus if you do something consequence. So now let's get into what some of the rules are. This is all good stuff. And so if I'll go kind of fast, as always, the beauty of this is YouTube records this presentation, puts it up on my YouTube channel. It takes them a while to process it, I believe. So, either this evening or tomorrow, you can go back and watch it. And so whenever we talk about being eligible for Medicaid, we have to talk about what the eligibility rules are. And so I'm going to give you some basic definitions. I want to keep this simple. When somebody goes into a nursing home, there's often a Medicaid application process, especially if the person anticipates being eligible for Medicaid. It doesn't do really any good to apply for Medicaid if you're not going to qualify, unless it's part of a strategic plan to qualify maybe months or even a couple of years later. But when someone applies for Medicaid, there's this voluntary Medicaid application. It's probably about 20 pages long, at least it is in our state of Louisiana, where the Medicaid applicant or their family or their designee, power of attorney, completes an application where all of the assets, the income, the prior transfers, all of that gets disclosed. And Medicaid, and as part of the Medicaid application process is giving Medicaid the permission to examine all of your bank records, tax records, property records, real estate records. So, the idea of trying to fudge on a Medicaid application is Medicaid fraud and should be avoided at all costs. But they do look at what you have. And first of all, they look at what's called the countable resources. They look at countable resources and they looked at exempt assets. Let's talk about exempt assets. There's a long list of them, but the main ones are your home and a car. So those don't count for purposes of, do you have too many assets to be eligible for Medicaid? So there's others. There's, prepaid funerals and, maybe personal items. So, but the big ones are house and car. Countable resources is really everything else. It's all those assets that you have, like money in the bank, financial resources, checking accounts, savings accounts, CDs. In our state, the full value of IRAs, retirement accounts are accountable resources. Real estate that's not your home, rental property, maybe you own property in an LLC, that's counted as a countable resource. Publicly traded stock, timeshares, United States savings bonds, really all these things that you own, cash value of life insurance, annuities, those are all countable resources that they're going to require that you consume those on your care prior to Medicaid paying for the nursing home cost. Okay, so that's the asset rule. And there's three different standards or three different tests for the countable resource or asset rule, depending upon whether you're single or there's two different married couple scenarios that I'll go through in about 20 seconds. The single person rule is if you have more than $2,000 of countable resources, you must consume all of those on your care before getting Medicaid. If you're a married couple, it depends on what the circumstances are. If both spouses are in the nursing home at the same time, they'll have to pay double because it's two of them in the nursing home. They might be paying $16,000 to $20,000 each month, but they'll have to spend all of their countable resources until they have less than $3,000 remaining. Doesn't take long to do that if you have a couple of $100,000 and you're spending $20,000 a month. But that's what you have to do. And then there's the married couple scenario where you have a couple where one spouse is in the nursing home. That spouse is called the institutionalized spouse because they're in a nursing home institution. And then you have a spouse who's living at home or in the community. That's why they're called the community spouse, because they're still living in the community. They're not in an institution. The rationale behind this law, which says under those circumstances where you do have a spouse still living in a community, the community spouse resource limit is 128,640, because the one who's still living at home has got to have something to live off of. So they only make that married couple who has one spouse still at home spend all of their community resources down to 128,640. No, you didn't put this on double speed or 1.5 speed. I'm just talking fast because I've done this a lot, and I know that you can go back and review it. So, and I don't like it when people who make videos talk too slow. I particularly don't like it when they talk slow when they're trying to figure out what they're going to talk about next. Okay, but that's me. That's just my rant here for a second. All right, so that's the three scenarios: 2,000 for single person, 3,000 for married couples, 128,640 for a married couple with one spouse in the nursing home, one spouse at home. Really, it's 130,640 because the community spouse can have 128,640 and the institutionalized spouse can have 2,000. So you add those together, 130,640. Okay. Now, I also want to go over the estate recovery rules. I mentioned it in my examples, but many people own a home. They come in, they're like, Paul, I want to protect my assets. We don't have to worry about the home. I know that's exempt. We don't have to talk about it, but we do, because it's not a countable resource, but it is an asset that Medicaid may attempt to force the sale of when you die in order to exercise its estate recovery rights, which every state has, to pursue reimbursement of its costs from the Medicaid recipient's estate. So just be aware that that's a rule that exists. Also, another important rule is some people start to think ahead of the game. Well, I tell you what I'm going to do. I'm going to take what I got. I'm going to get it out of my name. I'm going to put it in my kids' names. That way, when I go into a nursing home, I'll have less than $2,000. That's the plan. I like it. Let's do it. Well, obviously, it's not that simple. Medicaid caught on to that probably 40 years ago, or whenever people started doing that. So they started penalizing people with time period penalties for transferring assets out of their name, also known for Medicaid purposes as uncompensated transfers. So yes, David W. Paul, did I hear you correctly by changing ownership of a whole life insurance policy in the trust name due to the cash value? So yeah, you heard me correctly that cash value, if someone owns a life insurance policy, and under the typical scenario, dad or husband purchases life insurance, he may purchase a whole life insurance policy. Dad's going to be not only the insured, that's, when the insured dies, that's when the insurance company pays the insurance benefit. Maybe wife or kids, or maybe, one's primary, others are contingent. Those are the beneficiaries of the life insurance policy. But then dad is also likely to be the owner of the policy. The owner of the policy is the one who can change the beneficiary, the one who's responsible for paying the premiums. So if dad is the owner of his policy, which he likely is, and that policy has cash value, which it likely does, unless it's term insurance, which doesn't have cash value. But if it's whole life, it will have cash value. Or if it's universal life, it will have cash value. That cash value is a countable resource. So if a life insurance policy, if a individual is going into a nursing home and their only asset is a life insurance policy that has $30,000 of cash value, they will really be required to cash that value in, get the $30,000, spend that down to less than $2,000 before Medicaid kicks in with Medicaid eligibility. And of course, when they cashed the policy in, the life insurance death benefit went away as well. All right. Okay, good question from William Beasley. As I go through it, I gotta tell you, for 19 consecutive days, the quality of the questions in the live chat has been remarkable. I thought, doing this on YouTube, it's public, we'd get some wisecrackers out there who would just throw a bunch of garbage in the live chat. And that may and probably will still happen. But I will tell you, the The live chat has been really, really good. William, irrevocable trust, distributed income while in nursing home, and countable resource. So I think what you're getting at, William, is let's go back to my Brian and Lisa example. They put their $400,000 of financial accounts in their family trust. And as we'll get to in a minute, they may have named themselves as the income beneficiary of that trust. So as that $400,000 produces income, and that could be interest, it could be dividends, not necessarily the appreciation, because if that 400,000 is invested and just by appreciation, it grows from 400,000 to 420,000 to 475,000 to $500,000. We're not talking about appreciation here. We're just talking about income that's produced, typically interest and dividends. We often say that, Brian and Lisa, they are the income beneficiary of their trust. So if they're $400,000 of assets in the trust, those assets are not a countable resource. But let's say, hardly financial accounts don't produce much income these days. Let's say it's CDs and that kind of thing. That produces a 1% income return, would be $4,000 a year. That $4,000 would be considered income to Brian and Lisa. And if they don't spend it and they accumulate it, yes, that income would ultimately be a countable resource that would have to be spent. Now, if one of them went into the nursing home, maybe those assets would be counted toward the $128,640 that they can have. And quite frankly, there's rules on when a single individual goes into a nursing home, they do have to spend their income first. So if that $4,000 annual income translate to, let's call it $320 a month, and Lisa, as the surviving spouse, goes into the nursing home and she's getting that income every month, she will have to assign that income to the nursing home, that $320 a month, and then Medicaid will pay the difference between her income and the cost of the care. So there's some income rules there that we got to be aware of. Hope that helps, William. And so follow up with something else if you need to. Tough for me to answer all of the questions in the live chat because I don't get all of the context. It's almost when I'm talking to a prospective new client or client on the phone, or if I'm sitting at the table across the table from one, which I don't do very often. Just about all my business now is done on the phone. Sometimes people will ask me a question, and rarely am I in a position to answer it accurately. I often have to ask, well, tell me why you're asking me that question so I can answer your question accurately. But I love live chat so much. There hasn't been a question asked in 19 consecutive YouTube live presentations, and there have been questions asked on every single one of them that I haven't attempted to answer because I love the communication. That's why I'm doing these live. Okay, so I want to get back to the penalty for transferring assets out of your name. What is that all about? So the Medicaid version of a transfer or a gift or a donation or putting something into a particular type of trust, Medicaid's term for it is called an uncompensated transfer. It means you transferred something out of your name and you didn't get anything of equivalent value in return. Medicaid has a problem with that because Medicaid looks at that as you trying to divest yourself of your assets in order to qualify for Medicaid, and quite frankly, you probably were. So what is an uncompensated transfer? Well, if mom or dad, if they write a check to daughter for $100,000, that's an uncompensated transfer. If they put a piece of property in son's name, that's an uncompensated transfer. If they put assets into their revocable living trust, that's not an uncompensated transfer. But the problem is assets in a revocable trust are still considered countable resources of yours. So you still got to spend those if you go into a nursing home. But as we'll get to in a minute, if you put it into a certain type of irrevocable trust, that also is an uncompensated transfer, just like if you put it into your children's names. Some people said, well, I'll get around the whole uncompensated transfer thing because I'll disguise it as a Christmas gift, or I'll disguise it as a birthday gift. And you know what? The Medicaid rules don't have exceptions for Christmas gifts and for birthday gifts. So if you give $1,000 to somebody for their birthday, or for Christmas or whatever, that's still a $1,000 uncompensated transfer. If you give somebody $25 for their birthday, that's a $25 uncompensated transfer. All right. So, and another type of question we see is people tell me, Paul, I got it. I got the solution. What I'm going to do is I got this piece of land and it's worth $200,000 and I'm going to sell it to my son for $5,000. So he'll just give me $5,000. It'll be a sale and he'll get the $200,000 piece of land. That way it's protected and he only gives me $5,000 and yeah, I'll have to spend that, but it's only $5,000 for a $200,000 piece of property. Well, guess what? That don't work. They look at that too. And so if you sell an asset that is worth $200,000 and receive $5,000 in return, you've just made an uncompensated transfer that's valued at $195,000, and that has adverse Medicaid eligibility consequences. So now you know. Okay. Now, when someone applies for Medicaid, and you don't apply for Medicaid, somebody says, can I apply now? No, you can't apply for Medicaid until you're in the nursing home and you meet all of the medical requirements and all of that of needing to be in a nursing home. That's when the Medicaid application process takes place. Part of the Medicaid application process is a question. Have you, it may not be worded exactly like that. It may be worded just, have you transferred anything out of your name in the last 5 years? And so if you had done some uncompensated transfers more than 5 years ago, Medicaid doesn't need to know about it. They may ask about it. They may ask, have you ever transferred an asset out of your name, or have you ever transferred assets to a trust? And you're going to want to disclose it. But you're only penalized if that uncompensated transfer was within the last 5 years. Many years ago, when I started out as a lawyer 29 years ago, the period of where they would look back, as they call it, was 2 years. And then at some point, they changed it to 2.5 years. And then at some point, they changed it to 3 years. And then a little bit later, as I was getting into it now, they made it a 3-year penalty for transferring it to individuals and a 5-year penalty if you transferred it to a trust. So they were really discouraging people from putting their assets in a trust because the penalty period for transferring to a trust was longer than a penalty period of transferring it to an individual. But then they changed that and said for all transfers, it's a 5-year look back period, whether those transfers are to this particular type of irrevocable trust, which we'll talk about, or you just transfer assets to individuals such as your kids, same 5-year penalty period. Okay, is there any, let's see what else. So I pulled $9,000 cash every month for on-hand spending money and stuck in a mason jar, joking. Could that be considered uncompensated transfer? Well, it depends on who owns the mason jar. If you own the mason jar, David, which sounds like it's your mason jar, then it's not an uncompensated transfer because you're taking $9,000 out of perhaps an account that you own, and you're putting it into a mason jar that you own. Oh, by the way, as you may imagine, under all of the Medicaid rules, kind of cash on hand is a countable resource, which includes the proverbial cash in the mattress, cash buried in the backyard. In fact, if you have a safe application, you are consenting to Medicaid reviewing the contents of any safe deposit box that you have. So some people jokingly, as you say, David, they kind of, what if I, kind of take my money out of the bank and bury it in the backyard. Paul, we're going to be okay, right? I'm like, you're asking if the lawyer tells you it's okay to nudge, wink. Of course, it's not okay. So, but I'm sure people are doing it all over the place, and then they're lying on the Medicaid application about, the actual green money cash that they have because they're asked about it. Maybe they even get away with it. Who knows? But I don't want any part of it. So, okay. So that's a long answer, David, to your question. I don't know if I answered it, but there we go. Ron, is there any thinking that the 5-year look-back period will be increased to 7 or more? I think it used to be 3, wasn't it? So, yeah, 2, then 2.5, then 3, then 5. A lot of talk out there about 5 to 7, 5 to 10. We'll get to another one in a minute. But while I'm saying that, the thought going through my mind is, for example, every time they changed it, when they changed it, for example, from 3 to 5, that change to 5 years was only effective for transfers made after the date that the law changed from 3 to 5. So they grandfathered in these transfers that were made at the time that was the rule was 3 years. In fact, what we have now is there are some Medicaid or government programs that have gotten to the point where if there was any transfer made during the lifetime of the applicant for the benefit, then that makes them ineligible for Medicaid. So yes, could it go from 5 to 7? Yes. Could it go from 5 to 10? Yes. And not only could it, is it probably going to? Yes, because our population is aging, the cost of the care is increasing, the government's budget is shrinking, at least the available funds that they have to cover these kinds of expenses. People are living longer. Medicine is doing things that, yes, they're keeping people alive longer, but they're living in a state where they need long-term care for a longer period of time. So I not only think, is it possible or is there thinking, I think it's likely that they will continue to make it harder for people to kind of protect what they have and qualify for these benefits. All right. So excellent question there, Ron. And so going back to the penalty period, when they apply for Medicaid, have you transferred anything in the last 5 years? And let's say you have to answer yes to that question, and let's say it's a simple one. Let's say, you know what, 9 months ago, I gave my son $10,000 for whatever reason. It doesn't matter. You wanted to give it to him. He needed it for something. You gave your son $10,000 9 months ago, and you're applying for Medicaid. Otherwise, you would qualify. You have less than $2,000. You meet all of the, the health requirements where you need the care. So what's going to happen when you tell that on the Medicaid application, or you tell that Medicaid employee, yeah, I transferred, did an uncompensated transfer of $10,000 9 months ago. I gave my son $10,000. He needed it. He was in a bind. I didn't give it to him for purposes of trying to qualify for Medicaid. I gave it to him because he was in a bind and I wanted him to have it and he needed it. But nonetheless, it's still an uncompensated transfer. So what they're going to do is they're going to apply a penalty period. And it's a time period. And the penalty period, at least for our state of Louisiana, our state number is $5,000. Your state number might be different. They will do a mathematical calculation. They will divide the amount or the value of the uncompensated transfer, which was $10,000, by this Louisiana monthly cost of skilled care rate, which is low, but it's $5,000. It's a fixed number. When you divide $10,000 of the amount of the transfer by $5,000, this Medicaid rate, then that creates a penalty period of 2 months from the month when the person is applying for Medicaid. So that means they're in the nursing home, they made a $10,000 transfer 9 months earlier, they do the math, ineligible for Medicaid for the next 2 months. If grandma is going to stay in that nursing home, somebody's going to have to come up with the 2 months of private pay nursing home for her to stay there. And then the 2-month penalty period will expire, and the Medicaid applicant will then qualify for Medicaid. So be aware that that's how that penalty period works. If someone is in a nursing home and they made an uncompensated transfer 4 years and 10 months ago, and it was $200,000, don't dare apply for Medicaid, because a $200,000 transfer is going to trigger a 40-month penalty period. But if you made the transfer 4 years and 10 months ago, just don't apply. Privately pay for the next 2 months. Let the 5-year period expire and then apply. Have you made any transfers in the last 5 years? No, you're home free. And so you got to be careful about the timing of a Medicaid application, particularly if uncompensated transfers had been made in the past. Okay, so with that being said, the ideal scenario, how do you protect and qualify for stuff? The idea is really position what you have so it's under these threshold limits, and structure things so that at the time of a Medicaid application, you will not have made any uncompensated transfers in the previous 5 years. So how do you do that? Because what you have is likely more than the threshold limits. You transfer assets out of your name. Got a couple of options there. You can transfer assets to children. I'll go through some of the maybe pros and cons of that. Or you can transfer assets to what I'll call a family trust, and I'll go through the pros and cons of that. Why would people transfer assets to their children? It's simple. Working with a woman right now, she has one child. Child has mom's best interest in mind. Mom's going to be transferring some property to the child. That's all. Child's not going to do anything with the property. Everybody's goals of protecting the family property is preserved by transferring it to the one child. Now, what I would say what more people do, though, and because particularly if you have more than one child, but even if you have just one child and you transfer ownership of assets directly to the children, really you lose control. The donor loses control over those assets. It's possible that children could spend the money, they could get divorced, they could get sued, they could have IRS problems, they could be influenced by their spouse or their children to spend the money, or quite frankly, sometimes children die before their parents, and then those assets go on to the child's heirs. So a lot of parents, they want to keep that control over what they have, so they like the concept instead of transferring it to what I call a family trust. It's often what's called a spendthrift trust, so the children can't get to it until the parents die. If the children have divorces or lawsuits or creditor issues or IRS problems, then the children can't use their interest in the trust as collateral for a loan. They can't sell their interest in the trust. It's not going anywhere until the parent or parents who set up the trust pass away. And then when that happens, there's no probate. The trustee of the trust at that time will disperse the assets to the beneficiary. So many people like transferring their assets to what I call the family trust. And it is going to be a version of an irrevocable trust. And there's likely, if it's done correctly, a mechanism built in so that if the parents need to get the assets from the trust, there's a mechanism to do that in a way that still complies with the Medicaid eligibility rules. That's a topic for another discussion. These trusts are often called income-only trusts because just like I think David was asking me, or William was asking me earlier, oftentimes these trusts are arranged where the parents still want to get the income from the trust, which may not be much. I'm not talking about appreciation. I'm talking about interest and dividends that the trust assets produce. And many parents want that to happen to avoid there being any income tax consequences to the children during the parents' lifetimes. So that family trust, often called an income-only trust, sometimes it's called a irrevocable income-only trust, IIOT. You see that sometimes. It's called Medicaid income trust, Medicaid trust. There's no one right term for it. Different lawyers and different people call it different things. But all right, so they transfer 99 of ownership of a home into a revocable trust and maintain 0.01 ownership in an irrevocable trust to help maintain control. I guess you're asking me if that's okay. Again, I'm going to give you my best answer. If you retain 99.99% of ownership of a home in your revocable trust, it's still a countable resource subject. Well, it is the home. So maybe my best answer is Medicaid would have the right to pursue that 99.99% interest. Let me back up. Let me give you the actual rule. And this can vary from state to state, because I know that in our state, when someone transfers a home to a revocable trust, it's no longer an exempt asset. I guess Medicaid doesn't want to make it that easy for you to get it out of your estate to avoid Medicaid estate recovery rights. So then with the 99.99% in your revocable trust, you've just transferred that from an exempt asset to a countable resource, and then that would have to be consumed prior to Medicaid eligibility. If you took it out of the revocable trust and put it back in your name, now it's an exempt asset, but it's subject to estate recovery when you die, or at least the 99% of it is subject to estate recovery when you die. So I hope I answered your question, and so there we go. And if I went fast, feel free to go back and listen to it. Okay, so the beauty and what people like about this irrevocable trust concept is people do it while they're healthy, while they're, and age-wise it can vary, and nobody knows when they're going to be sick, but they really should and do take these actions at least 5 years before you go into a nursing home, which nobody knows when you're going to go to a nursing home. But most people wind up going into a nursing home maybe in their late 70s, their 80s, sometimes even into their 90s. So taking this action, which needs to be taken at least 5 years before you go into a nursing home. We see a lot of people who are maybe age 70, they're retired, they're not working anymore, and they have a few $100,000 and they have a home, and they have all good family relationships, and they just want to do what they need to do so they're not wiped out if they get sick. So that's kind of the common scenario here. And then what also people like about it is because your assets are in a trust when you die, all the probate's avoided. So married couples likely avoid those 2 probates, or as we call it in Louisiana, successions. Things in a trust don't have to go through that. When things are in a trust and the parents die, the parents likely named one or more of the children to be the trustee of the trust when the parents die. So the day after the parents die, that successor trustee can go in and disperse the assets out of the trust, as we called it yesterday in our presentation, terminating the trust and dispersing the assets out of the trust to the children, to the trust beneficiaries, to the heirs, whatever you want to call it. Okay, so there you have it. And what I'd suggest is next time you talk to somebody who is, starting to have the conversation, I wonder what would happen if grandma, aunt, uncle, mom, dad, husband, wife went into a nursing home. This presentation, which is about an hour long almost, will be on my YouTube channel. So you can go to the share button, you can text it to them, you can email it to them. So feel free to use it as a resource to help other people figure out what's this whole Medicaid planning thing all about. Pretty much everything I went through today falls under all states' rules. I mentioned a couple of things particular with our state, but even though it was particular with our state, many other states have the same rule that our state has. So winding down number 19 here, tomorrow number 20, it's going to be the last one. It's going to be, Ron, I'm hoping you come back on the front end with maybe give us the best on the last presentation on the humor side. Are there downsides to an irrevocable trust? That's Treston's question. Yeah, if we were sitting here talking about it, we'd talk about how maybe if you wanted to get assets out of that irrevocable trust because you wanted to go take a trip or spend them, or you just wanted to undo the whole thing, you'd need the cooperation perhaps of at least one or more of your children to undo it, because to make this whole thing work for Medicaid purposes, you cannot have just the ability to go undo it and put everything back in your name. If you had that ability, then Medicaid would require that you do that and spend all of the resources. So we have to put these restrictions on you which prevent you from having total control over these assets, which enable you to qualify for Medicaid, but they do restrict you if you want to completely undo the whole thing. So in an ideal world where the children are cooperative, the children realize, hey, I realize these assets are parked in a trust, and if my cooperation is necessary because some of these assets, my parents want them back, or my parents need them for some reason, I'm going to do what's best for my parents because I realize that my parents worked for these assets. Yes, if there's anything left when my parents die, it'll go to the kids. That's everyone's objective. But so anyway, if there's that kind of situation, then the downside of this kind of arrangement really just goes away. Tomorrow, we're going to talk about the 5 biggest mistakes that people make. It's going to be an emotional one for me. It's the last one. I can't believe how much I've enjoyed delivering the first 19 of these 20 presentations. One more to go. I'm already trying to figure out if you got some suggestions for other things that you'd like to hear or see. Bring them in the live chat. Hope everybody on tomorrow's going to be a great overview of kind of encapsulating everything that we've talked about into one presentation. So if you've thought of mentioning these things to others and inviting them to join in, finale is going to be a big one. It's going to be a good one tomorrow. I'm so much looking forward to it. I'll put it on my YouTube channel's community. I'll make it a post on the community tab where the link to tomorrow's presentation will be there. It'll be on LinkedIn as well. Feel free to just share that with as many people as you can. Tomorrow's going to be a tough one. Thanks to Ron and David and William and Johnny and Tresson and everybody else who's been contributing with phenomenal contributions on a daily basis. Look forward to the finale tomorrow. Make sure you like and subscribe. Tells YouTube people to share my videos with more people. That's the whole idea here, trying to educate as many people as we can. Y'all have a great day. Stay safe. See you tomorrow.